Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, and thank you for stopping by. All right, guys, the content that we're going to talk about tonight is another epic win handed down from SCOTUS. Now, this one is on level of Bruin for our gun rights, but not quite directly related. This one more so goes against regulatory agencies in the executive branch. Think three letters for me: ATF. Everything's going to be linked in the description box below. The potential for this is massive, and I cannot wait to hear what you guys think on this one. Now, we're always trying to earn that subscription. We'd love for you to help us get over that 400,000 mark. It's something we've been striving for. But if we earn it, please make sure to hit that bell so you get notified for our rights. Now, I'm going to say a quick word from our sponsor who made this video possible, and then we're going to hit on the other side. I cannot wait to walk through this decision with you guys. Now, today's sponsor is Core Essentials. For the first time ever, Core Essentials gives you the ability to easily adjust your battle belt, tighter or looser in tiny 1/4 inch increments, while sitting, walking, running, or even crawling through the mud without undoing or unbuckling your belt. So if you ate too much for lunch, let it out a 1/2 inch, or if you prefer, tighten it as much as humanly possible to hold all of your gear. It's easy and takes literally a second to make an adjustment. The magic is indeed in the hidden track system. And today, you have a discount code. Use Langley10 for 10% off at the link in the description box below. And thank you so much to Core Essentials for making these videos possible. All right, so the case that we're going into right now is West Virginia versus the EPA. This is a case that's all about regulation that the EPA basically made up. Sound familiar? ATF, ghost guns, like kind of on that same level? Well, the reason that this is so important, and I'm personally pretty amped about this, is because this is another nail in the coffin to all of the Biden administration's executive overreach in our realm of influence, specifically the sphere around the ATF. They make up rules, they interpret congressional dictates in whatever way that they want, and all of a sudden it's law. They're making law from the executive branch, which we've talked about is a no-no. Congress's job is to make law. But let me show you this case, this hearing, this opinion. This is a big deal, and I want to hear from you guys on this one, and please send it out. Let's get it. The question before us is whether this broader conception of EPA's authority is within the power granted to it by the Clean Air Act. Now, this is the setup for it, because that's what brought it to the SCOTUS. Both were premised on the agency's earlier finding that carbon dioxide is an air pollutant and may reasonably be anticipated to endanger public health or welfare. That sound familiar? Public health, welfare, epidemic of gun violence, health crisis. They're doing the same game across all the executive bureaucracies. By causing climate change, carbon dioxide is not subject to NAAQS and has not been listed as a toxic pollutant. Layman's terms, they tried to change carbon dioxide to a deadly pollutant, which gave them regulatory authority, which was the whole problem. They changed the definition of existing law, which is Congress's job. That's where they got in trouble. Again, think ATF. This is a big deal, guys. All right, check it out. So here we go, and where they lay out the opinion. Nonetheless, our precedent teaches that there are extraordinary cases that call for a different approach. Cases in which the, quote, history and breadth of the authority that the agency has asserted and the economic and political significance of that assertion provide a, quote, reason to hesitate before concluding that Congress meant to confer such authority. Meant to confer. Did Congress mean to do this? We don't think so. That's important. They're building the case that the executive bureaucracy overstepped Congress. We confronted the Attorney General's assumption that he could rescind the license of any physician who prescribed a controlled substance for assisted suicide, even in a state where such action was legal. The Attorney General argued that this case came within his statutory power to revoke licenses where he found them inconsistent with the public interest, public health, gun violence epidemic, gun welfare, public welfare. All this sound familiar? We consider the idea that Congress gave him such broad and unusual authority through an implicit delegation not sustainable. They're laying out the case here that this is not going to hold water, but I've got more. This is an incredible decision. It's very wordy, and it is linked if you want to read it, but this is big, guys. This is a massive decision. And yet, in each case, they laid out like the OSHA regulations, the CDC's overstepping, the FDA. They laid out a lot of examples of executive bureaucracies doing this. And yet, in each case, given the various circumstances, quote, common sense as to the manner in which Congress would have been likely to delegate such power to the agency is at issue. Again, is the agency overstepping congressional bounds? Yes, they are. They're about to get smacked. Check this out. Made it very unlikely that Congress had actually done so. Extraordinary grants of regulatory authority are rarely accomplished through modest words, vague terms, or subtle devices. Nor does Congress typically use oblique or elliptical language to empower an agency to make a radical or fundamental change to a statutory scheme. Does that sound like the ghost gun rule implementation that they just went through from the executive branch? They can't get it through Congress, they can't get it through the judiciary, and the judiciary just smacked down the executive overreach. This is a big deal because all of this ties to our executive branch is being checked by the judicial. This is the way the system is designed to work. As for the major questions of doctrine label, it took because it refers to an identifiable body of law that is developed over a series of significant cases, all addressing a particular and recurring problem. Agencies asserting highly consequential power beyond what Congress could reasonably be understood to have granted. Scholars and jurists have recognized the common threads between those decisions, and so have we. They recognize that all of these overreaches are becoming a problem, and they're about to make a ruling that's going to really curtail all of the Biden administration's executive overreach. Under our precedents, this is a major questions case. In arguing that Section 111 empowers it to substantially restructure the American energy market, the EPA claimed to discover a long-existent statute of an unheralded power, representing a transformative expansion in its regulatory authority. Now I'm just going to stop there for a second. Does that sound familiar, what the CDC did last year? What OSHA tried to do last year? Any of those things sound familiar? Well, under this 100-year-old statute, we can force all these things. Eviction moratoriums, ring any bells? This is massive. It located that newfound power in the vague language of ancillary provision of the Act, one that was designed to function as a gap filler and had rarely been used in the preceding decades. There goes back to that history and text and tradition. And the agency's discovery allowed it to adopt a regulatory program that Congress had conspicuously and repeatedly declined to enact itself. Again, he's saying they cannot do this because that is Congress's job. Here's the final one, and I love this one so much. Capping carbon dioxide emissions at a level that will force a nationwide transition away from the use of coal to generate electricity may be a sensible solution to the crisis of the day, because that's the whole point. They tried to change everything to get their climate change goals in order. But it is not plausible that Congress gave EPA the authority to adopt on its own such a regulatory scheme in Section 111D. A decision of such magnitude and consequence rests with Congress itself, or an agency acting pursuant to a clear delegation from that representative body. The judgment of the Court of Appeals for the District of Columbia Circuit is reversed, and the cases are remanded for further proceedings consistent with this opinion. It is so ordered. By the way, I just want to say that one day I want to be able to say something and say it is so ordered and have it happen. That just sounds cool. But the whole point here, guys, the reason that I'm amped, the reason I showed you this entire thing is imagine this exact same scrutiny with other lawsuits against the ATF. Imagine it when you're talking about pistol braces, what's defined as an SBR. Imagine it from a suppressor perspective, from a muzzle device, from M855 ammunition, all the things that the ATF is subtly trying to do things on, the bump stock ban. All of them are done through the rule process. They're all done through executive interpretation through bureaucracies of congressional law. They are about to get sued under the exact same statute that the EPA just got smacked around on because they did the exact same thing. The executive branch has been trying to overreach by translating existing rules and existing language, bypassing Congress. The Supreme Court just said, stop it. And they're going to have to, or there's going to be other consequences, which will not be nice. That's what I've got for you guys. Let me know if you're as excited as I am, and I will see you tomorrow morning on the Bullet Points. I'm Braden. See you later.